Okay, so welcome everybody today to our mock tribunal that is being facilitated by HR Recruit and Vista Employer Services. My name is Jo Thompson and I'm a consultant for HR Recruit. I'm joined today by the team at Vista who will introduce themselves shortly. Vista's team of experienced advocates will share their knowledge and experience and provide a real insight into how a remote hearing is run, how decisions are made, and how actions taken can very easily become key features of a tribunal hearing. If you do have any burning questions during the session, then please put them into the chat box facility. I'm now going to hand you over to Vista, who will introduce themselves and start the webinar.
Thank you, Jo, and thank you so much for having us, and welcome everybody to this, our first mock employment tribunal of the year 2023. We've all been really looking forward to running this one, and hopefully it's timely in the sense that it's relating to performance management, which I know is on a lot of people's agendas, obviously at the beginning of the year. So quick introduction to the team here, and also about Vista, who you may not know. I know we'll have some familiar faces on the call from previous events. It's lovely to see both you and also some new names as well. So Vista as an organisation, we are a team of employment lawyers, barristers, solicitors and HR professionals who provide support to some of the UK's largest employers on all things employment law and investigations and training. My name is Vicky Roberts. I am responsible for the learning team, and we provide training for HR professionals and for managers on all things employee relations, leadership, management and employment law. I'm an employment solicitor by background, but I now have the privilege of being able to take the experience into producing sort of learning interventions, as well as, you know, getting my hands dirty from time to time when Stephen will let me. So let me hand over to Stephen to ask you, Stephen, if you could, to introduce yourself, please.
Thank you very much. Yes. Well, yes, Stephen Foster. I head up the employment law team at Vista. More than 20 years of experience in getting my hands dirty, and always keen to support Vicky and the team in terms of sharing those experiences. So that really is a synopsis of me and my role, really.
Lovely, thank you. Let me come to you, Yvonne, next, if I could, for some introductions.
Hi, I'm Yvonne Saxon. I've had my hands dirty in HR for well over 20 years now, but these days with the lovely team at Vista, I look after HR services and diversity and inclusion services.
Great stuff, thanks Yvonne. And let me hand, last but by no means least, to Jen. Jen keeps us all on the straight and narrow, so let me ask you to introduce yourself if you could.
Yes, hi everybody, I'm Jen. I am the digital manager at Vista, so everything you see on our website, our resource hub, that's all my baby, and I also deal with our clients and our digital delivery to our clients as well.
So you can see what I mean, keeps us all on the straight and narrow for certain. We'd be lost without her, but that's for sure. So a combination of skills here today, really, in terms of trying to give you as true to life experience as we can of a tribunal, what's called a CVP hearing, a digital hearing that's going more and more the way of things since the pandemic. For those of you who have had chance to dip into our digital bundle, you'll have seen a little bit about what the case is all involving. We'll do a quick synopsis of that for you, so that if you haven't had a chance to have a look at it, it never got to the top of your to-do list, then not to worry at all. We can give you an overview. So what we're going to do today is give you, as I say, as true to life experience as we possibly can. We have truncated some things, so the bundle in particular. I know some of you that did get a chance to have a look at this, sort of a question the size of the bundle, and that's obvious from your experience that you've had them this thick in the past, and what we've tried to do is distill it down to the absolute crucial documents that we wanted to have a look at, and we will, and not having seen them won't be central it won't be a problem in the sense that they're not central. They will be explored in the evidence that you'll see. So what you will see is the on-the-day experience of a CVP hearing, a cloud virtual platform, as it's called, Zoom to you and I, in that sense, which is the tribunal and court services version of a secure Zoom, if you like. What we have done is broken down the cross-examination that you will see of both the claimant and the respondent's witness, the line manager involved, into various sections so that we can talk about the direction of travel of the cross-examination, why the advocate has taken that approach, and a little bit of more of an understanding of both the quality of the evidence that's available, but also how that applies to the law. Because for those of you that have been involved in a tribunal hearing in any kind of way, you'll know that the cross-examination just flies by, even though it might be quite lengthy. So from a learning experience point of view, we thought it was actually good to just try and break that down. So we'll do that as we go along. We'll ask for your views at various points. So if you can have your mobile phones ready, we'll be asking you to get involved with some polling later on. And that will include what you think the killer points are as far as the closing submissions. And you will hear from the mock employment judge in terms of the decision that will be being made. I'm really pleased that Stephen is on the call today because he is actually one of the advocates that you'll see from the cross-examinations. So we'll be able to get inside his head in terms of what took him in the direction that he did in terms of the cross-examination, which I hope will be really helpful for you as HR professionals, not only in terms of kind of flagging to managers when issues are of concern, but also understanding case preparation for those of you that either are in the middle of a tribunal hearing or preparation, or I've had to deal with one recently. And in that respect, if you are working for an organisation and helping that organisation deal with a tribunal claim, if you do want to sort of run some thoughts past Stephen or myself after the event, then we can facilitate that through Joe. As I say, we only act for organisations. We don't act for individuals in terms of our business model. So, but as I say, the offer's there if you want to chat to us about any issues that are ongoing and you act for an organisation and you work for an organisation. Therefore, you're helping a respondent. By all means, let us know. Brilliant. Okay, that's sort of introductions. We're together until 4:30. We're not going to do a straight run at this, so we will take a break at a point, so that we can get a chance to stretch our legs and what have you. So we'll take some breaks, but let's kind of get up to our elbows in the case then. First of all, familiarize ourselves with the issues that we're looking at, and then we will go to the on-the-day experience. So Jen, could I ask you to share your screen for me for the first sort of model that we wanted to have a look at? So this is a way that we explore with in our training and in our advice about the kind of legal framework for employing individuals. When you think about the nature of the employment relationship, it's governed by these three things: what our contract says, what our policies have to say for themselves, and obviously statutory employment law. The case that we're dealing with today is a case brought by Jude Cater against her former employer. She resigned in response to something that happened to her. Her employer is a fictional organisation called Sattler Services. And she says that she has been constructively unfairly dismissed by the way she was treated by her manager, Dan Lewis, and that treatment was discriminatory. And the ground of discrimination that she is relying upon is the fact that she had announced to her manager, to Dan, that she was beginning a process of reassigning her gender, from transitioning from female to male. Now, there's a couple of key points I want to explore here before we dive into the detail of this, and this is around terminology. You will see that we refer to Jude throughout using the female pronoun. What I'd like you to assume is that this was agreed with Jude as part of the tribunal process, because ordinarily, outside of something like this, you would expect somebody who is transitioning to male to be referred to using the male pronoun, or perhaps they, them. But just for the purposes of this is not us being disrespectful. I'd like you to assume that that's what's happened, and that will be acknowledged by the judge in their judgment. But that would also that's the case, as I say, as we refer to it throughout. The other piece of terminology I want to pick up on is gender reassignment. Now, for those of you that are familiar with this, you'll know that that is considered to be pretty outmoded terminology, but it is terminology that the law still uses. So inevitably that will come up in various ways. So whilst we would try and refer to Jude as trans wherever we can, the legal framework is talking about discrimination on grounds of gender reassignment or assigning her gender. So if anybody feels uncomfortable, discomforted by that, I completely get it. But as I say, we're doing it really for the sake of accuracy, because that's how it would be referred to. But the judge will acknowledge that in the judgment as we go along.
Vicky, can I just interject slightly?
Please,
there,
of
give you
course.
a chance to take a pause. Whilst we're on terminology, one of the quick questions that comes up on tribunals is how do we address members of the panel?
Yes.
And as of late last year, there has now been notification that you will refer to the judge as judge, which that sounds slightly odd, but it is gender neutral. So if you're not sure how to address the panel, you just say judge rather than sir, ma'am, those sort of formalities. So it's ideally to be less formal, but it also meets the pronoun requirements of nowadays as well. So it's just a quick question that often comes up.
There will be lots of advocates all over the place trying to get used to that, won't there? Because,
yes.
But yeah, really good point. Thank you. I'm just going to quickly flick off my camera and back on again because I can see I've gone a bit blurry. Okay, so as I say, yeah, some terminology points to look out for here. So going back to our legal framework, then, the facts of the case, we'll look at a timeline in a moment, but the facts of the case are these. Jude reports to Dan as her manager. She, unbeknown to Jude, Dan, her manager, has concerns about her performance, and has doubts as to whether or not what rating to give. And the rating system we've used is an on-track, off-track type rating. They use a 9-box grid type system. Dan, her manager, makes a decision to give her an on-track rating, even though he has doubts. And that happens at the end of December. In January, on the return to work after Christmas, Jude makes the decision to disclose to Dan, her manager, that she has decided to start the process of transitioning. At a point after that, in early March, Dan decides that Jude's performance is not at an acceptable standard and begins to manage the performance and starts with the formal process. So with Sattler Services formal process. In response to that, Jude is uncomfortable. So she decides to resign and puts in a data subject access request. And as part of that, finds an email where Dan is saying to his manager, wasn't quite sure about the rating for Jude. So decided with on track, almost could have done with something between on track and off track. And that's disclosed as part of the data subject access request. In response to that, Jude feels that she has experienced discrimination, so brings her claim not only in relation to constructive unfair dismissal, but also in relation to discrimination as well. And we'll look at the timeline in a little bit more detail in just a moment. But if we think about this in the context of the legal framework, obviously you've got a number of things to think about here. From a contractual point of view, remember that we as employers owe our employees this duty of the implied term of trust and confidence. And a constructive unfair dismissal claim can arise from either a breach of an actual term in the policy or actual term in the contract, or a breach of the implied term of trust and confidence. Stephen, in the context of this case and the facts as I've just described them, what's the key issues here from this sort of trust and confidence duty that we need to be considering?
Yeah, it's whether, and it's interrelated with the discrimination, which is why often these cases come together, is that trust and confidence is in the eyes of the person who claims the breach has taken place. It's very often that impression, and it's a question of fact. So therefore, if something has happened which is unusual, or is outside process or procedures, that could cause somebody to lose trust and confidence. And that's the crux of this case. The issue here is that there are performance procedures. Whether those are being followed correctly or not, we'll see. But that's the basis in this particular case of trust and confidence wavering and being lost. There's arguments about the promptness of a resignation. In this case, there's an approach on the performance on the Friday and the resignation comes in afterwards on the Monday. So that's not an issue in this case. And the resignation is with immediate effect. It's often understood on constructive dismissal, people have to resign with immediate effect. That's not always the case. So people can resign with notice and still claim constructive unfair dismissal. But for the purposes today and simplification, it's a prompt resignation following a performance meeting.
So it may be that the decision to start the performance management is tainted by the discrimination, and that in and of itself could create the breach of that breach of implied term of trust and confidence. But of course, it could be that the discrimination claim fails, but the constructive unfair dismissal claim still succeeds, couldn't it? So these two are separate, albeit related in the claimant's mind.
In this particular case, that's a common distinction tribunals will make is, okay, even if the trust and confidence has been lost, was that treatment duty transition in this case? Yeah. And there are two separate tests to be met.
Yeah, absolutely right. Absolutely right. So, of course, one of the other relevant aspects to this case is the ACAS code of practice. We know the ACAS code as being sort of sitting in that ellipse, if you like, between policy and our statutory employment law responsibilities to make sure that we don't unfairly dismiss an employee, whether that's constructively or actually. And you will know, no doubt, that tribunals will take the ACAS code of practice into account and also related guidance in that respect. So the decision to go formal is an element that will no doubt become relevant. Now, we will know as HR professionals the ACAS code of practice as being a series of steps that the ACAS requires. But we have a way of kind of thinking about the ACAS code in a very short-handed way that can sometimes really help managers to kind of distill what they need to think about. And Jen, if you could just share as the next slide, that would be grand. It's represented in this way. If you look at this table as being the columns being the what steps that an organisation needs to take, and the rows being the behaviours, the mindset that's needed. What we know the ACAS code to say is deal with things informally wherever you can. If you can't deal with things informally, or if you can't deal with things informally successfully, then formal process is required. And we know what that formal process looks like. It's letter, meeting, decision, appeal. And whether that's a capability issue or it's a disciplinary issue, we know those requirements are there. So the question as to why Dan has decided to go formal is going to be relevant to this issue of whether that the ACAS code has been followed. There is also the how behaviours, which are the rows here, which we distill down into be prompt, be clear, be open-minded, and be consistent. So it's a great way of kind of distilling. Now, we, as I say, know that the ACAS code talks in paragraphs, but it does give managers a good sense of these are the things that we need to think about. And just think about that as we're hearing Dan's evidence. Is there any evidence that perhaps he hasn't been prompt, or he hasn't been clear, or perhaps he even hasn't been open-minded? And what about consistency? Have a think about those as we're seeing Dan being cross-examined. So let's take a deeper dive into the chronology of events, because timing often is everything in these things. And here's our chronology in a bit more depth. So we're about a couple of years ago. So September or October 2020, Dan first has concerns about Jude's performance. January 2021, in accordance with the process, Jude is given an on-track rating. But as we know, as Jude knows from her data subject access request, Dan emails his manager to say he wanted to select something in between. 1 week later, Jude discloses she's transitioning. Obviously, at this point, she's unaware about that conversation between Dan and his manager. And Jude notices a change in Dan's management style around this time. She no longer has one-to-one meetings with him, for example. In March, Jude gets a bonus that is aligned to the on-track rating that was given in January. But yet in May, Dan starts the formal performance management process. And 3 days later, Jude resigns. So that's our sort of process, the process that was followed, the sort of timeline of events. What I'd like us to do before we start to see this all play out through the lens of a tribunal hearing is get your immediate view as to whether you think there's some risks here in terms of the both the constructive unfair dismissal claim and also the discrimination complaint. So I know you haven't seen all of the facts yet, but his gut feel is what I'm after here. So I'm going to share my screen in just a moment, and I'm going to ask you to have your mobile phones at the ready because we're going to use a Mentimeter tool to take a poll. So just while you're digging out your mobiles, if they're not immediately to hand, I'm going to share my screen. So if I could ask you either to, into your browser, put in www.menti.com or, and then enter the code 6402090, or you can use the QR code to get into the Menti. I'll just leave that up for a short while. And people are starting to vote already. So constructive unfair dismissal claim is the first question. Will Jude win her claim? Reasonably closely, finely balanced.
Interesting.
Yeses are going ahead a little bit. Okay, so our yeses have it for the for this first vote, and we will keep asking you the same questions. So we've got 123 in our first vote. I'm going to make a note of these as we go along. Plays 80.
It's gone on to 126 now, Vicky. 126 and 81.
126 and 81. Sorry, gang. Let's ask the same question. So will Jude win her claim that she's been constructively unfairly dismissed with the first question? What about discrimination? Will she win her claim of direct discrimination?
Vicky?
Yes.
Just a couple of, can you show the tag again for people to get on? But if you can't use the QR code, if you see at the top of your screen, www.menti.com, you can enter that code at the top there to get the voting.
I'll just reshare for a short while people are voting, in case the QR code is better. So let's see what we got. Ooh, real difference on this one. give it a
That's
couple of
good.
minutes to catch up. Are we all in? I think we are. So 37 in the yeses and 172 on the no's. Lovely. Okay. We'll keep an eye on these as we go along, and we'll ask you to vote again at various points. Thank you, everyone. And I will keep sharing it after at each point. Super.
Vic, is it worth mentioning at this point is that constructive unfair dismissal doesn't strictly exist in the legislation, but it's unfair dismissal. But the individual needs to prove that there has been a breach of the contract or implied term of trust. So burden of proof will be on the individual. And discrimination, there's a technical point where the individual needs to show enough information that there seems to be a case for that burden then to shift to the employer to defend it. So it's they're not easy claims to bring. Discrimination tribunals don't need a high bar. There's not a high bar for the individual to pass that test. But constructive dismissal is often seen as an easy claim, and it's not. There is quite a high burden on the individual.
No, absolutely right.
And the only other point I would make is in relation to the ACAS Code of Practice. Most organisations have the benefit of HR and keeping their policies up to date, and that's why it's important that the managers follow the policies and procedures. It will almost certainly meet the minimum standards of ACAS, and the reason why that's important is if you follow those procedures, you're avoiding a potential 25% or up to 25% uplift. So if the claim is won, there's a potential for uplift of 25% on the compensation. So it's quite a significant sum. And conversely, if the individual fails to follow procedures, you have the benefit of being able to argue for a discount of up to 25%. So again, this is the importance of training your managers and refreshing that training. So just to clarify those few points, because they are useful to keep in mind, particularly if you're with short servers. Sometimes we cut corners and take those risks, but it's worth knowing that sometimes it's still worth considering following the minimum procedures.
Absolutely right. And this is a live issue in our case for Jude, because she didn't raise a grievance, did she, before she resigned? She just left. So she could be at risk of facing, even if she's successful, a reduction in compensation, and that would be something that would be dealt with. Yes. Obviously, only once a substantive decision is made on the claims that she's made. But if she's successful, then that would be something that the employer would be arguing she should face a reduction in that compensation as a result.
Yeah.
And the test there is whether she has unreasonably failed to complete the process before she decided to bring her claim.
Yes.
Good stuff. Grand. Okay, let's have a think about on the day then. I'd like us to imagine that we are now at the day of our hearing. And back in the day, pre sort of digital hearings, there was always the issues of knowing where the car park was, having enough change for the car park, or making sure you knew how to pay for your parking, all of those sorts of things. Stephen, talk us through the practicalities of the sort of on the day experience now things are digital.
Yeah, you mentioned at the beginning about the digital, and I think the tribunals were pulled forward in terms of technology. They've been talking about it for a good decade or so, but it's pulled them forward, and it's not a bad thing. But there are some nuances to CVP. They are intending to proceed with it, despite COVID being behind us. Fingers crossed. Vicky, and the idea is they're going to make sure the tribunals can continue, and more tribunal rooms are or have the facilities to allow CVP. In terms of how they proceed, the big thing I would say is don't relax. Very often, just because you're sitting in your office or at home, it feels less formal. If you're sitting there in front of the judge, you would generally be on your best behavior. And as we can see now, even the slightest head movement, looking out the window, all of those are observed by the judge. So actually, you need to ensure that you give it the same respect that you would if you were attending in person. The other big thing I would say is that they are far more tiring than attending in person. And for our respondent attendees today, I would say is if you feel that it would be more appropriate to have a hearing in person, then say so. Just because the judge says, I want to do it by CVP, don't be pushed into doing that. As advocates, we're quite happy to have the debate with the judge. They are reluctant, time, cost, etc. But particularly with individuals where you feel the character would come out in person, push for it. Don't be afraid to do that. But bear in mind, CVP is convenient, but far more tiring, can be quite exhausting. The judges have now got used to it. But in the initial stages, they found them tiring, so there will be more breaks. In terms of preparation, it's the same as you would for a normal tribunal. Make sure you've got a copy of the bundle. Make sure you've got a clean copy of the bundle. There's a tendency, if you go to tribunal, when you take the stand, you will have what we call a clean copy of the bundle. It's a bundle with no notes, no highlights on it. Same with the witness statements, they're all clean. When you're working on CVP, you'll be tempted to work off your folder, which is absolutely fine. You can do that whilst you're not giving evidence. But remember, if you are a witness giving evidence, even by CVP, they will expect you to have a clean witness statement and a clean bundle in front of you. So you need two copies, the one that you've marked up and the one you will use if you are required to give evidence. Some judges are more lenient than others. Some have actually asked us to, or asked individuals to confirm there's nobody in the room and pick up the camera and demonstrate that nobody's sitting around them and to show that they have a clean copy. It's exceptional, but don't be caught out by that. So you need two copies of everything in terms of documents and statements. The other thing I would say is make sure that you have a chain of communication, WhatsApp, something that's encrypted, but it is offline from the tribunal system. Barristers at very early stages, I had a couple of hearings where even barristers were making comments to clients and was still on there, even though the judge had said, let's have a break, let's turn the cameras off, they'd left mics on. So it's a very simple mistake. Make sure you leave the room, make sure you've got alternative communication. But if you're taking a telephone call, leave the room in which you have the camera and the computer. So those are the main differences. Be prepared, still be smart, still be respectful, watch your body language, and make sure that you have alternative means of communication. Those are the key differences, I would say.
Wonderful. Great question that's just come on the chat here, Stephen. Can the general public attend virtual hearings?
Yes. All final hearings are public hearings, and therefore you can have the same observers. Obviously, they will need the link, but there's no reason why the tribunal clerk can't send that out. So if there's anybody on there that you don't recognise, make sure you or your advocate make an inquiry as to who that person is.
And of course, for those of you that have been in a physical tribunal room, you'll know that people that are attending as general public sit behind you. So you don't tend to kind of cotton on to them quite as easily as if everybody's got sort of an equal viewpoint on a screen. So it can feel very disconcerting, particularly for managers. So do warn them that that's a possibility. And I know there's a fine line between warning and scaring people in that sense, but I think it is worth making sure that they're aware that that's the case.
Yeah, and don't be afraid. You don't want to be seen as causing issues or making waves in front of the judge because of that respect. But it's important you know who is there, because I can give you an example in Birmingham. It was in person, but I would have done the same had it been CVP, is that we had a member of the press at the back of the room. I thought it was somebody that was with the witness because they sat on that side, and I just made an inquiry. It turned out it was the press. Now, obviously, the respondent employer didn't want anybody from the press there, but we just had a quiet word with the advocate for the claimant. And it wasn't in the claimant's interest to have the press reporting this, because obviously they were looking for work. So it's important to know who's in the room, and that doesn't change just because it's CVP.
Can I just bring you attention just to a couple of other comments on there? So Jackie's just put, what's your thoughts on claimant in person versus employers on CVP?
No real difference. What you will find is that where there's a claimant in person, the judge will, or the judge and the panel will often be seen to try and support that individual. It doesn't mean that they've got a bias, but whether it's CVP or in person, they will undertake some of the natural questioning and procedural issues on behalf of the unrepresented person. That's no different in terms of CVP. One thing that did happen in one hearing was that claimant in person was allowed to have their husband present, which I thought was exceptional, and we did challenge that. So even though they are unrepresented, the same rule should have applied. They shouldn't have people there muttering in their ear when they're giving evidence. So just make sure the support will be appropriate. If it's a disability adjustment, absolutely fine. But again, make sure that you check who is present. But in terms of procedure, the judge will support them in the same way, whether it's in person or CVP.
Amanda's asked, does it mean the press person or anyone else can be asked to leave?
It can. What happened in our case was they are entitled, it's a public hearing, but on the basis that both parties had raised the issue with the judge did raise that with the press, and the press decided to move on and go and see another hearing. So again, can't be forced. If it's a public hearing, it's a public hearing. But that doesn't mean you shouldn't challenge it if you have concerns.
The press will take a careful line, won't they, in terms of, if both parties have objected, they'll probably voluntarily choose not to be involved. Not absolutely definitely, but they will take a sort of sensible, pragmatic view on these things.
Absolutely.
Just a final one. Excuse me. Harvey's asked, what would happen if your policies are not up to date, but you still use the ACAS code of practice?
It's the ACAS code of practice is basically the baseline. So that's the measure. If your policy is out of date, there's questions there, but if you follow the ACAS guidelines, then you're following a fair and reasonable procedure. If you fail to follow your policy, and that's the higher standard, then that could be a breach of contract if it's contractual, or again, render it unfair because you've not followed what you said you would do. But ultimately, the baseline is the ACAS code of practice. Don't go below that line. Yeah,
absolutely right. And Jen, if you could just go back to our Venn diagram for us, please. Wonderful, thank you. This diagram sort of designed to try and remind you of that actually it sort of overlaps, if you like, that difference between policy and statutory sort of responsibilities on us as an organisation. Normally policies are non-contractual, but it depends on the sector that you work in. In some instances they are contractual, and if there is that, therefore that require higher standard, as Stephen says, then actually that would be something that would be expected. For the purposes of our case that we're looking at today, I'd like you to work on the basis that we're in the space of a non-contractual policy, just for clarity. Great stuff. Okay, Stephen, thank you so much. That gets us our heads in the zone in terms of being ready for on the day. So we're envisaging that we've got the bundle in front of us. We're all joined onto the platform. Let's just talk through the sort of early stages of the hearing on the day. So the judge would welcome all the parties into the room, and because this is a constructive unfair dismissal and discrimination claim, the claimant will go first. For those of you who have been involved in an unfair dismissal claim, so an actual unfair dismissal claim, you may be familiar with the fact that, slightly strangely, the respondent goes first, the employer goes first. In this case, because there's discrimination involved, the claimant will go first in terms of the evidence. Now, you may be familiar, because this has been the case for some time, that the claimant's evidence, which will be in the form of a witness statement, is taken as read by the tribunal. So in other words, it's not like, certainly when I first started in practice, the claimant actually read their witness statement out, which I quite liked, because actually it sort of settled the story into play, as it were. But now it's worked on the basis that the judge will have, and any other panel members will have read the witness statement in advance. So as we know, Stephen is the claimant's representative in this particular case. So what happens once the judge has welcomed the parties, and as I mentioned in the introduction, would have probably made some observations around the claimant's pronoun and confirmed that this is the case of Jude Cater brought against her former employer, Sattler Services, and it's a case of constructive unfair dismissal and discrimination, and confirmed that Stephen, Mr. Foster, is appearing on behalf of the claimant today. And another of our colleagues who isn't here today, but we will see captured on camera in a bit, Mr. McNaughton, is here on behalf of Sattler Services. Other than any preliminary issues that Stephen and Chris might need to deal with as respective advocates, it will be a matter then for hearing the evidence. And to do that, we would see Stephen calling his witness Jude. Jen, if you could just share your screen for me in terms of the slide cross-examination of Jude for me.
Whilst you're doing that, if I could just add something, because it's reminded me there of another good point for the preparation. You'll have heard the word they call in the witness. The witness will confirm that it's their witness statement, but you'll also be required to swear on oath or affirm to say that everything you say will be given the truth. Now, if you're affirming, there will just be standard words, and that's fairly straightforward. If you're going to give oath on a particular holy book of some sort, generally most tribunals have a Bible, etc., etc. But if it's a slightly different religion, then just make sure that whoever the person may be, that you have those discussions before the day of the hearing. And if you think it would be helpful, make sure that they have a copy of their holy book available, so they could place their hand upon that book should they so wish. But it's one of those things that tribunals, you'll be surprised how strict they will be on that. If somebody says they are of a certain belief, I've seen a hearing be held up for an hour, hour and a half, whilst everybody's running around, the clerks are running around for that particular book. So it's another good tip just prior to the hearing. It just it ruffles feathers and unnerves people if everybody's flapping around. But sorry to interrupt there, but it's a good point.
It's a really good point, Stephen, and it's absolutely a crucial point that you just don't want, as I say, as you say, everybody to get unsettled with. So how this would work is that Stephen will call Jude to give evidence. Now, call comes back from the days when everything was, when it is done physically. So the witness will walk to the table where there is that clean copy of the bundle that Stephen's mentioned, and either the court clerk, and that's often the case in a physical hearing, but often the employment judge will take what's called the oath or affirmation. So the clerk or the judge will either ask for a repetition or will hand a card to Jude to either swear on her chosen holy book, or a civil secular version is then to affirm. So I'd like you to assume that Jude says, I solemnly and sincerely declare and affirm that the evidence I will give will be the truth, the whole truth, and nothing but the truth. Stephen then will take Jude to her witness statement. And the purpose of this is to technically put that evidence into the hearing as evidence, isn't it, Stephen?
Yes. It's all that was required is a quick review of the statement, make sure there's no changes. This is the point as well where often last minute nerves kick in and people say, oh, I just need to clarify, or I just need to tweak this. You won't be able to make substantial changes to your statement, but if there is a typographical or if there is a correction, that's the point to just say, that is my statement, but paragraph 6, I'd just like to clarify X, Y, and Z. And that doesn't present an issue at all. That happens in quite a few cases, so don't be afraid at that point to speak up and then explain if there's any slight amendments there.
Grand. Okay. And then Stephen hands over his witness, his client, if you like, to his opposing party's advocate, who in our case is Chris, to be cross-examined. So talk us through, Stephen, what the purpose of cross-examination is.
The purpose of cross-examination is to push and pull the witness and to test it and to present the case of the side in which you're representing. So they have to put their version of events to the witness so that the witness can comment on that. And that's really what the purpose is. They can ask all sorts of questions under cross-examination as long as they are relevant to the issues. Just because you've not dealt with something in your statement does not mean that you won't be cross-examined on that point. So it's important to be prepared on your bad points, which you've not put in your statement and you're trying to gloss over, as well as the points that you've got in your statement, because a decent advocate won't miss those points. So it's to test you, it's to pull out the issues and to put the version of events of the other side to you. To show that what you're saying is either wrong or misunderstanding at best.
Lovely. Thank you, Stephen. And we'll see next then Chris cross-examining Jude. So as all good advocates, there is a structure to Chris's cross-examination in terms of the points that he's looking to get across. And so we've split this cross-examination into 4 key points for us to see how that plays through and pick up any points, observations, questions that come up in each one. This first part that Chris is going to deal with Jude is to explore the correlation that Jude has made in her mind that going formal in the formal performance management process is equal to being negative to her. So let's see this first piece of cross-examination, and then obviously any thoughts or points on the chat. Thanks, Jen.
Okay, so just to understand your claim, one of the main areas of your claim is that you've been constructively dismissed, and that's on the basis of conduct that is calculated and likely to destroy the relationship of trust and confidence. Is that right? Is that how you understand it to be?
Yes, yeah.
And just before we focus on that alleged behaviour, prior to the issues of performance, you had an otherwise good relationship with your manager, Mr. Lewis.
Yeah, I did. Dan and I, we used to chat at work. We'd have one-to-ones regularly. They weren't kind of formal one-to-ones, but he'd always get together with me and the rest of the team on a one-to-one basis and have, you know, good chats. And it's an opportunity for us to always discuss how things were going.
Yeah. And is it right that your main concern is that you disclosed to Dan your decision to transition? And in response to that, are you saying that there were manufactured performance concerns that he sought to tackle with you?
I think that when I got the DSAR, it showed that there was some discussions happening behind my back about my performance that he had ample opportunity to speak to me about and didn't until after I told him about my transition. Then suddenly it all came out of the blue. It's like he was accelerating the process. So it feels to me like he's just chosen that as a reason to get me out because my transition made him feel uncomfortable, which is really clear from that point forward.
Okay. Well, would you say that it would be good and appropriate management for a manager to address and support performance concerns?
Yeah, absolutely.
Yeah. The alternative, just to put it positively, the alternative would be a manager who lets performance concerns drift and perhaps lets an employee's performance wither on the vine, which would expose them to more vulnerability of dismissal. Would you agree with that?
I'm not quite sure I understand what you mean. So,
well, a manager that tries to reduce a performance gap is a manager that is providing security of ongoing employment. He's making you improve, and that you're therefore less vulnerable to dismissal. Would you accept that?
Yeah, absolutely.
And would you accept as well that if there is a performance problem, would you accept that it's a good thing for a business to work with an employee to find out what the problem is, what the concern might be?
Yeah, definitely. And that would have been what would have happened before, I would assume. It would come up in those one-to-one conversations.
Yeah. And is there anything wrong with a business offering you support or additional training in relation to any performance concerns to again help you reduce a performance gap?
No, not at all.
No. And is there anything wrong with a manager wanting to then meet with you regularly to discuss any additional support and training and see if it's working?
Well, that's what I would expect if there was a performance issue. But in my case, it was just getting brushed under the carpet. And it wasn't until I explained my issue that he then started to have a real problem and went straight in for the jugular with my performance.
Yeah, but I'm just dealing with the notion of that step and whether it's a good thing or a bad thing.
Okay.
So I think you'd agree that meeting with you regularly to see if training and support was working is a good thing. It's a positive managerial step.
Yeah, I would agree with that.
And is there anything wrong with checking to see if the additional accommodations or support or training was indeed working and the employer's back on track?
Yeah.
These are all incredibly healthy, supportive steps for an employer to take with regard to an employee's performance might have dipped, aren't they?
Yeah.
And ahead of you resigning from your employment, did you read the performance improvement policy within the organisation?
Yes, and it does say that that performance would potentially be looked at on an informal basis. So it's up to the manager, as you said, to have regular meetings with the employee and explain if there are any issues.
Okay, so this is the first section of the cross-examination. Stephen, get inside Chris's head for me as the respondent's advocate. What's he trying to achieve here? You're just on mute, Stephen.
I was bound to do it sooner or later, wasn't I?
Your T-shirt for about 5 minutes before I do it.
Yeah, he's been quite heavy in and repeated the questions. What he's trying to say is, look, performance management is all about support, help, security, and therefore how can that lead to a loss of trust and confidence? So that's the purpose of that. He's showing, look, there's nothing unusual here. There's no breach of trust and confidence. Actually, this is the employer doing the right thing and to retain you in your employment. So it's not a hard question. There's been no mention of discrimination, no mention of breach of trust and confidence. It's just a case of pulling, and you will see how the witnesses come along and say, yeah, that's right, that's reasonable, and then try to pull that back.
Wonderful. How convinced are we on the chat? Give me your thoughts.
Silence.
People are just typing. Too early to say. Fair dues, Mark. Fair dues. So there's a view that Judah's overreacted, but he hasn't covered himself in glory either. I see that. Yeah, but why was the informal step overlooked is a really good question. More detail still needed is a common theme. Yeah, lovely. Vulnerable because of the absence of the informal management. Absolutely right.
I think there's an important point there, Vicky, as well, that somebody said about the informal stage. As an advocate, the one word I picked out of there was potential. She actually says in there that there's the potential for informal. So as an advocate, you could have opened that up a little bit more to say, well, that doesn't mean it's guaranteed or it will happen every time. So I'm not sure if Chris goes on to that, but just that one word can make the difference with a good advocate. So yeah, it's good.
Yeah, absolutely right. Well done. And the lens through which we need to look at this is the point that you made earlier, I think, Stephen, from a discrimination point of view, that the burden of proof is reversed in discrimination claims. So all a claimant needs to do is bring forward facts from which the judge or the panel could say, yes, there is a link between Dan's decision making and Dan's management and her protected characteristic.
Yes.
The fact that she decided to transition. And from there, we have to prove the absence, or the employer has to prove the absence of discrimination, i.e. that it was in no way connected, and the test is that high. Yes. So what we're looking at here is there enough to raise these questions at this point? And there's a lot of more information needed, which is absolutely fair enough. So let's go on and have a look at where Chris goes next in his cross-examination, which is to explore in more depth this link between the decision to leave and the performance management. Thank you, Jen.
Sure. So I think your concern here is that a step might have been missed in relation to informal and formal performance management. Is that right?
I think it was missed for a very long time. Yeah.
Yeah. But would it be worse for the manager to miss it for a greater length of time? Or would it be better for the manager to eventually provide all of those good support mechanisms? Which of the two would be better treatment of an employee, would you say?
Well, it needs to happen eventually. I appreciate that, but take 4 months from the evidence that I've seen.
So you actually wanted the performance management sooner rather than later. Is that your argument?
I would have expected it to come up in a conversation on an informal basis if there was an issue.
But you resign rather than letting any of that support mechanism be put in place, don't you?
Well, I was called into a formal performance management meeting, having never had any discussions about issues around my performance prior to that.
And you believe that the performance concerns in your case, the performance concerns arise actually out of the disclosure that you're transitioning. Is that right?
Definitely, yeah.
Yeah. Why do you raise a data subject access request?
I just had my suspicions that there was something more to the issue, and I didn't feel comfortable raising one prior to my resignation. It's literally, I think it was the Friday when Dan started the formal process. I thought about it over the weekend, and I thought, do you know what? I know what his angle is. He'd been uncomfortable with me since my disclosure to him about my transitioning, and I just thought, I just rather jump before I'm pushed, and that's what I did. And to ensure, I just wanted to, really kind of reassure myself what the issues were. That's why I submitted my data subject access request.
Sure. Let me just deal with that sentence very quickly as well that you mentioned. You say you wanted to jump before you were pushed.
Mm-hmm.
Do any of the elements of support that I described to you, all the positive elements of support, do they align with being pushed out of your employment? And let me just repeat them back to you. Work with you to understand the concerns, support you and offer you additional training or time or accommodations, check in regularly with you, and then let you know if it's working. Do any of them align with being pushed out of your employment?
No, I understand that those processes are supportive in supporting someone's performance, but the fact of the matter is, from what I could tell, and from my experience with Dan, I told him about my transition, and then literally after I'd got the bonus and we had our milestone meeting, it was just literally at that point, out of the blue completely, that I've had issues with my performance apparently since September, October year before.
Sure.
And so it's for me, it didn't feel supportive at all. It felt like he'd gone straight into a formal process without any prior warning, without any prior conversations, which made me feel like he had an angle. And that's what I mean about jumping before I was pushed, because I was convinced he had an angle, and I couldn't have won either way.
Okay, so the mismatch, I guess, between the purpose of the policy being supportive versus the way it was being perceived is the continuing theme of Jude's evidence. From your point of view, Stephen, watching this as the advocate of Jude, what are you picking up on when you come to cross-examine her manager? What's the key issues that you're spotting here?
The key issue is that she's emphasising the delay, and the only thing that really has changed in that timescale is the fact that she's mentioned the transition. So she's now connecting the reason for the treatment or the failure to take the step that is in the policy must be down to that transitioning. So this is where the discrimination element's coming in, and this is where she's now triggering that burden of proof now for the employer to come back in when we hit that examination and that evidence to say, well, what was your reason for skipping that step? If it wasn't the transitioning, what was it? So, and that's important to again, to the respondents on the line here, is it can be a bad decision. But even if it's a bad decision, it doesn't necessarily mean in this case it's down to the protected characteristic, the transitioning here. So sometimes it's best to say, look, I made a mistake, I made a judgment call. The reasons why I didn't do it was this. If that was wrong, that's fine, but it's still nothing to do with the transitioning. It's not a strong defense, but it's sometimes a defense that employers need to just be straight about it, rather than dodge around the issue and start fudging arguments. So this is important. It's a simple issue, but it shows how employers can get really into the depths of it. The advantage here is Chris has shown two things. One, that the performance issues by the claimant's own evidence were spotted prior to the transitioning conversation. And secondly, this statement jumped before pushed. So again, when you're a witness, be very careful on the language, whichever side of the fence you're on, as to the language that you use. It would have been far better to say the only thing that's changed was the transitioning conversation, rather than say that I felt I've jumped before I was pushed. So it's thinking about how you'll deal with those issues. So key points really in this small section, which are crucial to the claim.
Yeah, lovely. Okay, so let's go on and see where the cross-examination goes from here. Thank you, Jen.
Yeah, and the DSAR helps employees sort of lift the veil, doesn't it? That understand what people's true thoughts are at a time when they're not perhaps directly communicating them to you. So you go through the DSAR and you find that as of the 12th of January 2021, you'll have read it within the material within the bundle. Dan Lewis is saying that you are not a great performer. Do you accept that? That was his comments as of the 12th of January 2021.
Yeah, and he didn't inform me at all.
No. Just do please focus on my question though. You accept that he was saying at that time that you are not a great performer. Your performance, therefore, is not great and would warrant attention. Would you accept that?
Yes.
And he also runs through a 9-box rating of your performance at the time. And he identifies, again, 12th of January 2021, significant improvement is required. Do you accept that?
Yeah.
You also accept that it's better for a manager to give the support and performance mechanisms and the performance accommodations and time to improve than to let it drift.
Yes.
And he has those performance concerns with you. They're not apropos of nothing or in response to your disclosure about transition. They are prior to your disclosure about transitioning. That's right, isn't it?
Yes, it is.
And in relation to your comment being wishing to jump before you're pushed, all of the key cornerstones of the performance improvement plan, you and I are in agreement, are helpful and supportive. They're good management. And not only are they good management by way of a helpful cycle, if the first cycle of identifying the problem, working with you, meeting regularly with you to see if support and additional training is working and keeping you updated about it, if that cycle doesn't work once, the performance plan takes you through that cycle several times, 3 times before it dismisses you. Do you accept that?
I don't know how it would have panned out. It was just really clear to me that he'd gone straight into the formal process. And I get what you're saying, but to me it felt out of the blue.
Exactly. If the main thing that offends you is that it was out of the blue, it conflicts rather with your desire to have it addressed sooner rather than later. You're really suggesting that you would have never liked to have been subjected to performance improvement, aren't you?
No, I just think that it was his responsibility to talk to me about it on an informal level when he first recognised there was an issue with the way I was performing. And that's what I feel is, that's why I feel that his impetus for starting the formal process was my disclosure.
So Chris, talk to me about Stephen, talk to me about one or two of these one-word answers that Chris has managed to draw out of Jude.
Yeah, what he's doing now is pinning them down. So he's forcing her into a corner, and you'll notice his questioning in the first section we watched was very open, just getting her to relax, start the conversation. Once he's now got the points that he wants and got her on board to make some admissions, he's now drilling down and he's now pushing her into closed questioning. So we talk about open questions and closed questions, and now he's getting these one-word answers, the yeses or nos, which really stick with the tribunal. Another thing you'll notice he's doing is that when she gives him the point that he wants and she says no, he then repeats that. So again, psychologically he's landing the point with the panel. So these are all slow points where he's adding things together. And the DSAR is an important point, and I'm not sure again if he comes onto it, but what he's pointing out is that she could not have known about that email on the 12th of January because she only got that after she resigned. So it's almost an invalid document as far as the resignation is concerned. It may be relevant now to the point of discrimination on timing, but it's now knocked that point out of the water in terms of constructive unfair dismissal, because that couldn't have been in her mind or the reason behind it.
And yet she still makes the point, doesn't she? There is the impetus for managing performance was my disclosure, she says.
Absolutely.
So he needs to deal with this, doesn't he? So let's have a look at.
Yes, he's got to deal with that because this is the crux of the case now for her.
Yeah. Absolutely, absolutely right. So Jen, let's have a look at this, the final section then of Chris's cross-examination. Thank you.
And I would agree that he should have got to it sooner rather than later. And it's his evidence, and let me put it to you to see if you perhaps accept it. Because let's remember, managers aren't perfect, and you agree you otherwise had a very good and healthy relationship with him. It's not easy to tell people that their performance isn't great. His view is that he perhaps should have got to it sooner rather than later and was giving you more positive feedback to keep you motivated. So isn't his sin just perhaps being too friendly and protective of you? Could you accept that when you look at your relationship and you also look at the concerns being clearly evident prior to your disclosure?
I think I would agree, apart from the fact that you said that about the relationship being friendly, because it wasn't after I'd made my disclosure. He didn't treat me in the same way anymore. He stopped having one-to-ones with me as regularly. He didn't ask me about my weekends. We didn't have the same level of relationship we had in the previous year. So that's why I've made the inference I have. It's not just the performance issues, it's also his treatment of me that had changed. So yeah, I've just put 2 and 2 together, and that's what it makes for me.
And what would your view that if all of those significant performance improvement requirements were left unattended to, that would be worse management of you than actually addressing them? I mean, that's got to be right, hasn't it?
Yes, technically.
And the performance improvement cornerstones, the consider the problem, support you and give you feedback, and 3 rounds of it, they are nothing near being pushed out as a process, are they?
No.
And you didn't have a clue at the time how that process might have panned out.
No, but it's like I said to you before, he went straight in for a formal process, and that just didn't seem right to me.
Well, is there any evidence to suggest that you could have gone through the performance improvement process? That's the name on the tin. It tries to improve your performance. Is there any evidence to suggest that working with the business, working with Mr. Lewis through one cycle of that wouldn't have got you back on track?
Yeah, I'm sure it would have done, but I don't know that I would have been speaking to someone who'd been prepared to listen or support me at that point.
Any evidence that he wouldn't have been prepared to support you in the plan itself?
Just because of the lack of communication that we'd had from the beginning of the year.
Well, I would suggest to you, rather than jump before you were pushed, you just jumped too early. And it's only after the DSAR that you found out that there were genuine performance concerns prior to the disclosure of you transitioning, which no longer fits with your case, does it?
I guess that's your opinion, yeah.
Okay, no further questions. Thank you.
Okay, so that's the end of the cross-examination, and there's a super point. I see you've responded to it, Stephen. I was reading it too. Why a PIP wasn't put in place? Where is the informal performance management, which we will see in, Stephen, your cross-examination, won't we, of the manager, Dan, to understand this? Because what will you be looking to try and achieve, Stephen, with your cross-examination of Dan?
Is to show that he has treated her differently is the first hurdle I need to clear, because if he's treated her differently, that puts the business back on the hook as into this was discrimination. The only reason for that must be the transition. So that's the first thing, and therefore again that will then help me go into the issue of it wasn't unreasonable for my client to have lost trust and confidence in this employer or this manager in the way that she was being managed. So again, that strengthens one or both of those arguments. But I was smirking at the end because what you'd seen there was Chris use that closed questioning again to get her to actually say yes. That might be your opinion. Yes. So she's affirmed his opinion. So he's done a very good job, I would say, there, in just unpicking what is a difficult case for the respondent to defend.
Yes.
So it's good to show those questioning skills.
Yes, good stuff. Okay, so we'll look next then at how do we address Dan's change in behaviour that's being described. So we'll see Stephen cross-examine Dan in relation to the evidence that he gives. But I think we'll do that after a well-earned break. So we'll take 10 minutes if that's okay with everyone. What I would suggest you do is stay in the call, but let's take Stephen's advice from earlier. Make sure you pop yourselves on mute. We'll gather back together at 22 minutes past. And obviously we can't necessarily see you, so we will crack on at 22 minutes past. But please do take a well-earned break, stretch legs, check emails, all of that good stuff. Grab another cup of coffee and popcorn if that's your thing. And we'll see you at 22 minutes past, where we will take a quick check-in in terms of your views, and then we'll see the cross-examination of the respondent's witness. Okay, welcome back, everybody. Wasn't that a quick 10 minutes? So what I thought we would do is get the products of your mulling as the kettle was boiling in that 10-minute break, and ask you the same questions a second time that we asked at the beginning. Now we've seen the claimant's evidence through her cross-examination. So I'm going to take you back to the Mentimeter if I can. I can see some people are there already, well done, but I will reshare for those of you that aren't. And I'll ask you the questions in terms of first of all, the constructive unfair dismissal. So let me share my screen. And I will also reshare the QR code for those of you that need it again. So again, it's menti.com and it's the same code as previously, but also same QR code as previously. So let's have a look where we're getting to then. So constructive unfair dismissal is the first question. Will she win? I'll get marker pen ready. Oh, one or two still coming in. Very firm view towards no, gang, at the moment. Okay, let's count. Whoop, still one or two coming in. Okay, let's call it there then. We've definitely got a strong view as far as the no, so I'll capture it here at 163 in favour of no and 23 in favour of yes. So an absolute swap compared to our opening position. Very interesting. Let's see what happens as far as the next question then, the second vote around the direct discrimination claim. Thoughts, please. Coming in thick and fast, and no is still the prevalent at the moment. Okay, let's capture it there then. Again, very strong view, still consistently to the no. 140, 142 no's. Plays 43 yeses. Stephen, thoughts on that?
Yeah, I think this is a great example of when you're in tribunal, CVP or in person, is that when you hear one side of the evidence, you really get a real big swing. People become very confident or very demoralized in their case. Remember, we've only heard one side of the case. So this is a classic example of, particularly on the constructive dismissal, I think there's been a big swing. I can't remember the figures, but this is a real life example of how emotions flow in a tribunal hearing.
Yeah.
You suddenly feel lifted or demoralized, and then suddenly you hear the other side and you think, oh, maybe not. So very good.
Yeah, absolutely. And as you say, complete swap. So it's 126 yeses in the first vote. It's now 163 no's. So a big change, as you can see. I need one of those swingometers, don't I, rather than my fairly scruffy note on the back behind me.
Jon Snow when you need him, yes.
Absolutely right. Yeah, well done. Absolutely right. So let's just pick up on, there were some really good points coming through on the chat about the timing of the various issues here. Yeah. So if we recap on a couple of crucial dates, 6th of January, just on return to work from Christmas, Jude discloses to her manager that she is made the decision to transition. She doesn't know at that time that there are performance concerns at all, and she still doesn't know up until the point at which she's invited to that formal performance meeting. It's only when she feels uncomfortable about the decision to go formal does she put in her data subject access request and discovers an email that is a few days after her disclosure on the 12th of January to say, I want to make some decisions needed to make some decisions in terms of the Jude's performance rating, and Dan discloses that he's had some concerns and they've gone to way back. So this timing issue is crucial. Stephen, talk us through it from your point of view.
Yeah. There's two crucial facts here in this case, and this turns to the whole case. One is the reason, the timing of the discussions, and why was it left so long, and the second is was this related to the transition or the transitioning conversation? She's got to clear those two hurdles. Now everybody's focusing on the 6th of January, but we've lost sight of this. Doesn't change the fact that performance issues were identified in the last quarter of 2020. So this is really where the employer needs to say, look, yep, hold my hands up, not done a particularly great job. I've done it for these reasons, whatever they may be. But ultimately, this has nothing to do with the transitioning conversation. The performance issues arose long before. So in the claimant's evidence, we've seen nothing there. So this is typical where you can focus as a respondent or a claimant on a couple of points which are your strengths. But actually, you've got to look at all the surrounding facts. And that's what the employer should be doing now, is to say, look, okay, now hear what we've got to say. The DSAR is a bit of red herring, as we said before, in that wasn't in her mind when she resigned. And it can't have been the reason why she felt she'd been treated differently. The whole issue is the timing of the performance conversation and missing that formal stage. The employer now has to explain why we missed a stage and why we delayed. And those are the two issues. There's lots of facts and lots of dates here, but that's what a good representative and HR advisor will be doing, is saying, well, what's the point we've got to look at? What's the real issue here? Why do we miss the formal informal stage, and what was the reason for the delay? Can we show that was nothing to do with trust and confidence, and it wasn't sufficient for her to lose? It's got nothing to do with transition, and it's got no basis for the loss of trust and confidence, which was the support, and we want to get you back to where you should be. You're going to have several chances to improve, which was the examination. So hopefully that explains. Focus on the issues, not on get tied up and hooked on specific details or documents.
Yeah, quite so, quite so. So let's have a look at this then. Let's see how the cross-examination goes, and we'll get inside your head, Stephen, at various points, if that's all right with you.
Yeah,
so
absolutely.
we'll do like we've done with the cross-examination of Jude. We'll stop it at various points. So just a quick reminder, just as with Jude's cross-examination, Dan, the manager, will be giving his evidence on oath in exactly the same way. So in this, it's almost a swap, if you like. So Chris, who is Dan's representative, calls Dan to give evidence. Dan gives his oath or affirmation. Chris asks Dan to stay there, as it were, while Stephen, as Jude's advocate, cross-examines. So let's see that in action. Thanks very much, Jen.
Good morning, Mr. Lewis.
Good morning.
As the judge has indicated, I'm now going to ask you just a few questions in relation to your statement and the statement of the claimant, Jude. If I may, I'll just check a few details with you. In terms of your experience, you would class yourself as a reasonably experienced manager, wouldn't you?
Yeah, I think that's what most people would say.
And from your statement, it appears that you're familiar with the performance improvement procedures in terms of an informal process and then a formal process. Is that right?
Yeah, I've been involved in those kind of issues before.
Now, in terms of the claimant, what she's saying is that she found that when she advised you that she was transitioning, and that took place, I think we agreed on that on the 6th of January, 2021, so just after the new year of 2021, we agreed on that.
Yeah, that sounds about right, yeah.
What the claimant is saying there is that the meetings and the regular one-to-ones which you refer to in your statement became more infrequent and shorter with her, and so there was a change in the way that you were managing the claimant. Would you agree with that?
Yeah, I would. It was a challenging time generally, and you know, meetings of that nature became a bit more difficult, not just with Jude but with other colleagues as well.
And in terms of that, you say it's a challenging time, and it was, time was precious. We've got no evidence of that in the bundle, have we? There's nothing to support what's changed in the business at this time.
Not really sure what kind of evidence could be produced. I mean, just in terms of the calls on, me as a manager at that time, there was more of it. I mean, I had a lot of kind of, strategic meetings and what have you. But I can't think of what I personally could have put in a bundle to demonstrate that, but it doesn't mean it didn't happen, Mr. Foster. There's nothing in it. You've not disclosed your calendar to show an increase of meetings in other areas, and you've not disclosed any increase in business, have you? I think my calendar would have looked much like it always did, to be honest. I mean, I don't really change my calendar. If a senior manager pulls me into a meeting or, wants my time, then I give my time, whether or not my calendar catches up with it. That's something different altogether, to be honest. And remind me, is the size of the team, as I understand it from the claimant's evidence, there's only 3 finance managers. Is that correct? Yeah. And that didn't change after the 6th of January, did it? No.
All some lovely one-word answers again here, aren't there? Well done. So what are we trying to get to here, Stephen?
What we're trying to do is undermine the credibility without going into just calling him a liar. What we're saying is, look, you're not supporting yourself here. And this is an important point in that judges hear these cases day in, day out. The best evidence is not what each witness will say on the stand. It's what's supported by the documents. You'll often see them with their crayons and their highlighters, where they'll literally do big ticks on pages or scribble away. They love to see that. So this manager, first thing that jumps out here is he says he's familiar with the policy. It's not in the bundle. So he says he says that he's busy. He should have access to his calendar. Would have been easy for him to support that. So it's important that this witness supports what he's saying, and he's not. So really what we're saying is, yeah, you're saying this, but there's nothing to back you up. Yeah. And then we'll get into in a moment, we'll get into the key issues, but in a moment we're just gently nudging this person to say, look, what you're saying is not supported, is it?
Yeah, grand, lovely. Okay, let's see where it goes next then. Thank you.
Can I just deal with a point? Sorry, Vicky, before we go
Yeah,
into
of course
the
you
video.
can.
Somebody's
Absolutely,
made
yeah.
a point about privilege, and I think this is really, really important because we see this
Good point.
every so often. This doesn't suddenly, I don't know whether it comes out in our articles or whether we see this bit of privilege. This email, the internal email 12th of January would not be privileged, and that's absolutely categoric. The reasons for that is it's not legal advice, so it's not between your legal advisor and the manager. And secondly, there's no litigation in contemplation at that stage. Even if somebody raises a grievance, that is being held not to be sufficient to render it to be legally privileged. So remember, all emails, all documents, post-it notes, text messages, private phones as well, are all disclosable.
And of course, the reason why it was identifiable through the data subject access request search is because Jude's name was obviously, central to it.
Yeah, that's an important point about data protection, how you file things, and secondly, that privilege is an exception under disclosure of data protection, but litigation is a different rule. All relevant documents would be disclosed, even if it wasn't disclosed as part of the DSA. Yeah,
but as you say, there was no litigation in contemplation here at the time the data subject access request was made. So in that sense, it would not have been deemed non-disclosable on that basis either.
On both counts, under the DSAR and the litigation, it's a disclosable document. There's no doubt about that.
Yeah, great stuff. Okay, let's go on and see where the cross-examination goes next.
So let's move forward then. In terms of the performance, what we're saying here is that you have a system where you grade people as on track or off track. Now, your case, as I read it today, is that in September and October of 2020, you believe, or you try to convince us, that there was some performance issues. Is that correct?
I had some questions, concerns, observations about Jude's performance. Yeah.
And your statement of paragraph 5 in terms of the informal and the formal process is that you have a good relationship with your team and you can talk about any issues. And to use your phrase, you're able to nip things in the bud. You didn't take any steps to nip any issues in the bud at that stage, did you?
Well, I don't think that we got to a stage where I needed to take such a step. Otherwise, I would have, but that doesn't mean that the concerns weren't there. I just didn't exercise a judgment to do anything different than what you've seen in the kind of history of Jude's one-on-ones and performance at the time. It was a judgment call. I made a judgment call, and you know what that was.
Well, let's look at the evidence, because the judgment call is contradicted by the evidence, isn't it? Because in December 2020, which is 2 to 3 months after you say that there were some concerns, you actually have a meeting with the claimant and state that she's on track. That's correct, isn't it?
Yeah, I mean, I awarded Jude and on track. Yeah, that is correct.
And not only did you say that to her, a month after that, even you confirmed that in writing, didn't you?
Yeah, well, one followed the other. I mean, one side allocated that on track in December. January was the confirmation of what I'd done in December. So there wasn't a further assessment, so to speak. Whatever you get in December is what's then confirmed in writing in January.
And in January, we've already agreed that on the 6th of January, you're told a transition, but to use your language again, one follows another, and therefore 26th of March 2021, the claimant receives a bonus payment, which is also related to that finding that they're on track. That's correct, isn't it?
Yeah, I mean, it would be unusual for an on track to be recorded in December, January, and then no bonus or a merit pay award in March. So these things just kind of follow on.
Well, that period is a period of some 6 months. So whatever concerns, if you had these concerns, let's take that on face value. If you had those concerns in September, October 2020, 6 months later, you've still not nipped anything in the bud, have you? In fact, you've gone the other way. You've confirmed this individual is on track and performing well?
I don't quite see it that way, because, like I say, whilst I awarded the on track, that didn't mean that I didn't have some measure of concern. It's just that the point at which I had the meeting in December, the concern wasn't sufficient not to award an on track, if that makes sense. So the sense of disquiet was there. I just didn't think it was merited to express that sense of disquiet by doing less than on track. If there was some, you see, it's kind of an all or nothing, off track, on track. If there was a middle ground, close to on track, or not quite off track, then that's what I would have chosen. But it isn't there, so I had to exercise my judgment. I didn't want to demotivate, and I thought that I hoped really that my kind of awarding of an on track would be ultimately merited and justified by seeing some measure of improvement. So
but you can only a person who receives a bonus and is told they're on track can't change or improve anything unless they know, can they?
Well, I think they can, because people can change according to Jude had not been that bad over the course of her time with me. So my hope, expectation was that, perhaps we're just saying something that was, just one of those things. So I let it be. And went for the on track award.
So it can't have been anything significant. You've let it be. You've decided not to do it. But unless somebody's aware, they can't actually improve unless they know that they need to improve, can they?
Well, I just fundamentally disagree with that. I think people improve, their performance, quite often, and whether or not it's because they're told, or because they're self-motivated, because they overcome some temporary blips. That's what happens in my experience.
But surely isn't that the purpose of your informal nip it in the bud conversation?
Well, you nip it in the bud if you're concerned enough to take that kind of action. My concern at that point in December hadn't reached a stage where I felt I needed to say or do anything to nip it in the bud. You may say that's a wrong judgment call, but I'm in that case, I'm just guilty of a wrong judgment call.
I suspect there's going to be quite a few people on this call that's thinking, if I had £1 for every time I heard that, oh, it's the system's fault, there aren't enough ratings options. So thoughts on the chat for me in terms of how convinced are you by this explanation of not nipping in the bud? Thoughts on that would be gratefully received. Not at all. Not very convincing. Yeah. It's difficult to explain it, isn't it, why he's had these performance concerns and not raised it.
This would be interesting in the poll, and this is the point I made, where that swingometer you talked about, Vicky, is you can see just 10 minutes has made all the difference, hasn't it?
Yeah, absolutely right. But of course, the question still remains, yes, it might be poor management, but is it discriminatory poor management? Yes. In that sense. So let's go on and have a look at where, Stephen, you go next in this cross-examination, shall we?
Brilliant.
What, before the chat explodes?
So what made it so significant when you did raise that almost 8 months later, 2/3 of a year later? What changed?
Well, I mean, what changed is that nothing had changed from the kind of thoughts and sense of disquiet that I had in September. So by that time, the hoped for improvement shift hadn't come. So that's when I took the view that I needed to say something and do something.
But if your usual process is to nip things in the bud or to deal with matters formally, and you didn't do that with the claimant, you must admit that you've not treated the claimant in the same way as you would have somebody else, surely.
No, I merely because I say, you know, I'm aware that I, you know, sometimes need to nip things in the bud. That it's not unusual for it to, in my recollection over my management history, for it to flow like it did in this particular case. I mean, you know, all you're talking about is the judgment as to when you kind of start the nipping. So I wouldn't say it's unusual for me to, you know, give people that kind of opportunity to, you know, just, you know, make progress and, you know, to improve that. I think I've done that before.
The real reason why I would put it to you, if I may, Ms. Lewis, is that you weren't able to communicate with the claimant. You treated the claimant less favourably because you were aware they're transitioning. That's the real reason, isn't it?
No, it's not.
Well, if it's something not too serious, as your words were in your paragraph 7 of your statement, something of a little concern, and you've not treated them in the same way of nipping it in the bud, and it's clearly nothing significant because there's no evidence and you've not described it as that, you've treated the claimant differently. And the only obvious reason is that the claimant is transitioning. That's correct, isn't it?
No, you're incorrect. I mean, like I say, I did consider that what I was doing was nipping it in the bud, and the way that I thought about it and approached it, I don't think is significantly different to how I have or would have approached it had Jude been John or James or Jen. I mean, it's just the kind of judgment.
Did it never cross your mind that the claimant spoke to you early in the new year and that the period of transitioning may have been already occurring, and therefore that may be an explanation for any of those little concerns that you had at the time?
No, not really, because, you know, like I say, in that period where I was sensing some measure of downturn, obviously I was unaware of the background. When I spoke to, or when Jude spoke to me at the turn of the year, she didn't indicate that that was having any impact upon, you know, how she went about doing things. So if it didn't occur to Jude, it didn't occur to me either.
But if your policy is of transitioning is one of support, within that 8 months where you say you were aware, and we've seen no evidence, I remind you, we've seen no evidence, but you're aware of some concerns about performance, there's no evidence of any support being provided to this individual at all, is there?
Yeah, well, you can say that. You know,
well, I'm inviting you to challenge that. It's not for me to say that. That's the obvious truth from the evidence, isn't it?
Well, trusting someone to get on with their job, I think, is a way of supporting them. I don't always need to get in the way, and I didn't.
I think I've just seen the comment of the course on the chat, which is, never mind nipping in the bud, a tree could have grown in the time it took him to do anything, which I just love, Margaret. Thank you so much for that. What's also going on in the chat, which is I think very, very valid in all of in the discussions, which is actually the absence of doing anything, and that timeline point again in terms of the disclosure of the transitioning, it is indicating discrimination. And you're thinking like a judge, by those of you that are thinking like that. What we're looking for is the absence of any reason whatsoever to be a link between the behavior that is unfavorable and the treatment. And remember that discrimination can happen unconsciously, it can happen unintentionally. And most people judge their behaviours by their intent. I don't intend to offend you, and therefore I haven't offended you. But of course, I can offend somebody unintentionally. We know that from discussions around harassment. Same applies with things like discrimination. And this is, Stephen, what you're getting at here, aren't you, in your cross-examination?
Absolutely. So we're just pulling out. I have to say this manager is doing well under pressure, but you can see the majority not convinced. There is Olivia's made some points here, is that it is two sides, and it relates to a point I saw on the comments earlier, which is no grievance procedure was followed. Don't have to follow the grievance procedure. If she can turn around and say, well, trust and confidence was gone, there's no way the grievance was going to repair that. It's broken, it's gone. That would be the simple response to that. But this is why this case has ended up in tribunal. There are two sides to this argument. You can see both sides. This manager may have done it for all the best reasons, but didn't need to have been placed himself in this position. And we're talking about transitioning here, but we see this very often with disability cases where people allow things to slip, and then suddenly we do something because something has happened, and then we get lumped in to say, well, this is all because of my disability. And had we addressed it and made reasonable adjustments, or considered reasonable adjustments, we would have been absolutely fine. But we tend to be full on or full off, and this is a lesson from this case, I think.
Absolutely. There's also quite a few comments about we should have disclosed more evidence from other witnesses to say, well, I had less meetings with Dan at the same time, or the point about the diary or one-to-ones and demonstrating a not drop off of that. All of that would have been very helpful evidence, of course, to be able to differentiate Jude from the point that she was making, and say it isn't about her transition, it was just a general behaviour. And the absence of that evidence may speak of the fact that it's not there. It may speak of the fact that people aren't going to be willing participants, because of course what you don't want to do is force people who currently work for the organisation to give evidence against their will in that sense.
Yeah. Now, witnesses leave, but I think this is a good point I always say to people when I'm picking up these cases is, if you're going to make a statement, each paragraph, point me to a document. So if you're going to make that and say, well, I was busy, where's the document that supports that? Now, you can't do that with every paragraph, but if you work on that simple basis, it doesn't mean you don't say something because you can't back it up, but wherever you can back that paragraph up, just put page 73, page 104 to 110, and that then negates all this. These thoughts that you've got on this chat are exactly what will be going through tribunal's mind, not just the judges, but the panel as well.
Yeah, quite so.
The human beings. So you're swinging and making the same decisions and questions that they would make on the day.
Absolutely right. Great. Let's go to the next section then, Jen, of the cross-examination, if we could. Thank you.
Okay. Well, let's move to the action that we do know that you took on the 21st of May, 2021.
Yeah.
Out of the blue, the claimant says you called the individual into a formal performance management meeting. That's not your normal course of action for something minor that you would normally nip in the bud, is it?
Well, I think that's a way of nipping it in the bud. So again, it's just part of that approach that is sometimes appropriate to resolve things. I don't see performance management as, something that is negative. I see it as a positive thing, because it provides the opportunity, through a structure to help restore someone's performance if you have concerns about it. So I don't see it as a negative thing at all.
You've just said that you decided not to take a nip in the bud informal course of action because it may demotivate. How do you think that made the claimant feel that she's told you she's transitioning from to male, and before she knows it, she's then all of a sudden out of the blue, having received wonderful feedback, on track feedback, she's hit with a formal performance management procedure? How do you think that made the claimant feel?
Well, I know how it made the claimant feel because she says it in a witness statement, and I'm presuming you've read it too.
And you can understand why she felt like that, can you not?
Well, I understand that's how she felt. So that I can't. People feel how they feel.
But
so.
knowing that you have had a good relationship, knowing that you nip things in the bud and you can talk about all issues, and suddenly to be hit with a formal performance management procedure, you can see how the individual has lost their trust and confidence in the way that you're managing them, can't you?
Not really, no, because like I say, performance management, it to me is a positive thing, not a negative thing. So,
but that's in the general sense, isn't it? I'm looking at the precise actions. You've got somebody here that's told on track, on track, on track. Here's some money, you're on track, and not 5 months after they've told you, then they're suddenly hit with a form of performance out of the blue. You can understand how somebody would feel with losing their confidence, losing their trust in you as a manager, can't you?
No, I mean, look, that's not to say that I don't give Jude the right to feel how she felt, but if you're saying, do I think it's inevitable or obvious that it would, as she has put it, destroy trust and confidence, I'd say no, because it's not been my experience that has been the case before. Look, telling someone that you have concerns about them can always come as a shock to the system, no matter when you do it, how you do it, what tools and levers you use, because some people don't like to hear negative things. So it doesn't come as a shock to me. In kind of the broadest terms, I can say I understand how anyone feels because it's been explained to me. But if you're asking me, is it inevitable and is there anything wrong in the approach? No, I don't accept that.
You don't see anything wrong. So you don't see that there's complete contradiction in the performance records between what you're saying performance was like and the actual on-track statements and bonus payments. You don't see anything wrong in that.
No, there always comes a moment in performance management where what has gone before is changed by what you say next. That moment always comes, Mr. Foster.
But if there is no evidence of any performance issues, which there's not, if there's no evidence to support the way in which you've treated the claimant here, the only natural conclusion, would you not agree, is that the only thing that's changed here is that the claimant's told you the transitioning?
No, I don't. That's not changed anything. So I can't agree with you on that.
But nothing's changed between September. There's no evidence to suggest there's been a change between what you say that happened in September, October, and when you took the formal action. The only thing that's changed is that in between that period, the claimant's told you they are transitioning. That's correct, isn't it?
Well, if the height of it is that you're saying it's only me saying it, I can accept that. But that is evidence of what happened in my view, because that's what I saw. So I'm afraid I can't agree with the suggestion that there's nothing, because there's what I'm saying.
Okay, Mr. Lewis. Well, thank you very much for your time. I have no further questions.
Thank you.
He's so polite at the end there, isn't he? Thank you. Thank you for dragging me through backwards. Yes.
Absolutely right. Absolutely right. And there is a likability factor in this, isn't there? In terms of there was some sarcasm that was sneaking in when he was becoming under pressure, Mr. Lewis, a little bit, wasn't there? And that sort of thing will play through to a judge, won't it, Stephen? For sure.
Yes. They don't miss this. And the other important thing is what he doesn't do is he's not evasive. No. Even though he's on the back foot, he tries to explain himself and he's clear on where he's coming from. So credit to this witness on a difficult point. He sticks to his guns. The thing that Tribunal will spot immediately is evasiveness. If he was going around the world trying to avoid the question, that antagonises. So it's important that he's turned up, he's well prepared, and he's doing the best that he can in the circumstances.
The mask just slip slightly with the sarcasm, which you need to try and avoid if you can, can't you? Because sarcasm
and body language, as we said before, particularly on CVP, is emphasised, and it doesn't go down well. It's not. It's just not it's not the right environment for either of those things.
Yeah, and it's completely understandable what happens. That it's a defence mechanism, isn't it? It's fight or flight going on, but it hopefully illustrates the point how powerful it can be in a negative kind of way. Okay. Yes. Yeah. Okay. Good. All right. So we need to think about making some decisions because we've now heard the end of the evidence. So I need the help from you, and let's take us back to the poll for one last time. So I'll just reshare my screen, same as previously, so in case you don't have it to hand, just to go back into the Mentimeter poll. And then I'm going to take you to the third vote. So let's take you to, will she win her constructive unfair dismissal again, please? Now you've seen all of the evidence. How interesting, very balanced. Just give it a few more seconds before we capture this. Goodness me, look at this change.
It's impressive, isn't it?
Okay, let's capture it there then. So we've got, oh no, one more. Sorry guys. So we've got a 77 yes. So we've had a swing from 126 yes to 23 yes to 73 yes on the constructive unfair dismissal over the time. Let's go on to the next one.
I think I should bring this in when I'm actually in tribunal. It could,
yeah, it could help, couldn't it? What about the direct discrimination claim then, everyone?
Well,
others. And equally balanced again. Interesting.
that really answers that question we had in the chat. I think just before we broke is, grievance procedure or no grievance procedure, why is this in tribunal?
Yeah.
These two responses show why you've got the parties equally divided here.
Yes, absolutely. Absolutely right. So let's stop it there then. We've got 80 for yes, highest number of everything, and 97 for no. So the swing on yes for the discrimination over the time has been 37 initially, 43, so went up slightly, and then has gone up to 80 in terms of the yes vote for the discrimination claim. So as the view stands, the majority view is that the unfair dismissal claim would not, the constructive unfair dismissal claim would not succeed, but the discrimination claim and the discrimination claim would not succeed either, but it's by a narrow margin, certainly in the discrimination claim, and reasonably so in terms of the constructive unfair dismissal. So what, sorry, Stephen, was there a point you were going to make? Yeah, apologies.
One point here, because you made a point about unconscious bias, and I think this is a hot topic, certainly in 2022. And I know we train on it because it is something to be conscious of. But somebody said here, would a person's individual belief bias be a reason cited as discrimination aside from the timeline of events here? Not in this case. And the reason why I say that is that discrimination cases can be brought against the individual and the employer. But in this case, it's purely against the employer. The general approach is tribunals are not there to embarrass people. They're not to hang people out, saving the most extreme cases. They might go a little bit further. But here they would just say, look, whilst we've heard the reasoning behind this, we are satisfied the only change here was the transition. So they won't call it, they won't pull the individual out or point them out to have unconscious bias. That's not what a tribunal is about. They will use the facts that were put forward to them, and they will take into account this claim is against the employer. Not the individual.
Yeah, absolutely. It's a really good point. Where you see claims being made against individual managers is often where there's behavioural issues in terms of banter, that sort of thing. So if you think about Jose Mourinho, you think about Clarkson, you know, those sorts of behaviours are that have triggered the claims against the individual managers. Whereas this is a manager exercising his management responsibilities. I know we have views on how well he's done it, and they're very evident in the chat. But it's about the decision being made on behalf of the organisation, effectively, if you like. Good. Okay, so evidence is over. Normally what would happen would be some closing submissions that would be made by both parties. So Stephen and Chris would give kind of observations to the judge. I'm going to use your brilliant comments on the chat as those closing submissions to me as the mock judge for today. After those closing submissions, there would be an adjournment, and the judge would go away either for a few hours or for longer in order to be able to make a decision. Now, as this is a discrimination complaint, one of the things I'd like you to envisage is that I'm three people, because normally it would be a panel of three, and they would confer and make the decision, and that decision would either be unanimous or it would be a majority-based decision. And then it would be the judge that would give the decision. Now, that happens in various different ways. We're going to give you a decision today with some reasons, just to be able to give you that sense of an understanding of where the decision has been made and why. So I will kind of give you that decision. And I've been sort of reflecting as I've been hearing the evidence and seeing your comments to construct my decision. And so this is pretty close to what would happen. And often a judge will read it out, won't they, Stephen? Because they will have kind of constructed their argument. So you will see a little bit of this coming from me in that sense. Often what happens is that the judge will go through the facts of the case and the law before reaching the decision. And you're like following it, thinking, right, that's okay, where's it going? I'm going to play a little bit with the order of things. I'm going to give you the decision and then talk through the reasons, just because I think it's easier to understand often when you see it in the context in terms of the way it's being described. So this is the judgment of the tribunal in the case of Jude Cater and Sattler Services PLC. In the course of this hearing, this tribunal has heard evidence from the claimant, Jude Cater, and from Mr. Dan Lewis, the claimant's former line manager. This tribunal has had before it a bundle comprising documents relating to the process that was undertaken and email correspondence relating to it, and also some of the respondents' relevant policies. This tribunal has also been assisted by helpful closing submissions from both parties' advocates, for which this tribunal is grateful. The decision of this tribunal is as follows. The claimant's claim of constructive unfair dismissal is well-founded and succeeds. The claimant's claim of direct discrimination on grounds of gender reassignment is well-founded and succeeds. These are the reasons for this tribunal's decision. Starting with the constructive unfair dismissal claim. And we'll start here with the law. Tribunals take guidance in relation to issues of constructive dismissal from the leading case of Western Excavating and Sharp. If the employer is guilty of conduct, which is a significant breach going to the root of the contract of employment, or which shows that the employer no longer intends to be bound by one or more of the essential terms of the contract, then the employee is entitled to treat himself as discharged from any further performance of that contract. If there is a repudiatory breach of that contract, the employee must resign in response to it without delay. It is clear on the evidence, and this tribunal finds, that the claimant resigns directly in response to that conduct, something that is not disputed by the respondent in this case. The issue that is central to this case is whether the conduct of the respondent's manager, Dan Lewis, amounted to a repudiatory breach. And implied into every term of an employment contract that an employer will not, without reasonable and proper cause, conduct itself in a manner that is calculated or likely to destroy or seriously damage the relationship of trust and confidence between the employer and the employee. Breach of that implied term, if established, will inevitably be repudiatory by its nature. Where an employer discriminates against an employee, then those acts of discrimination may represent a breach of the implied term of mutual trust and confidence. The question of whether or not there has been a repudiatory breach of the duty of trust and confidence is to be judged by an objective assessment of the employer's conduct. The employer's subjective intentions or motives are not relevant. So this tribunal's conclusions are as follows. We've heard from Mr. McNaughton, the respondent's representative, in his closing submissions that the claimant jumped too soon, and that even in the formal stages, the purpose of the policy is to help improvement. Whilst that is the stated intention of the policy itself, I also have to consider the role of Mr. Lewis in the person executing the policy and his decision to begin with the formal process, and in the context of the timing of the incidents in this case. On the evidence, I find that there were opportunities for Mr. Lewis to raise his concerns informally, not least the milestone meeting. I find that the respondent had put forward no good reason for beginning with the formal process. No evidence has been put before this tribunal to suggest that the performance concerns were serious or that a change in circumstances had arisen. This tribunal is required to take into account the ACAS Code of Practice, and the foreword to the code states that many potential performance issues or grievance issues can be resolved informally. A quiet word is often all that is required to resolve an issue. However, when an issue cannot be resolved informally, then it may be pursued formally. The respondent has submitted to this tribunal that it must be right that an employer has a choice whether to start managing an employee, when an employer can start managing an employee's performance. But on the other hand, the claimant submits that starting the formal process indicates that the decision is predetermined. I'm guided by the decisions of the Employment Appeal Tribunal that both providing misleading information to an employee and the absence of an impartial formal process are in themselves repudiatory breaches of contract. So I must consider the motivation, consciously or otherwise, behind Mr. Lewis's decision on the 21st of May to bring the formal process. The extent to which Mr. Lewis was impartial in this choice is also central to the claimant's claim of discrimination. And in the light of the decision of the Employment Appeal Tribunal in Shaw and CCL Limited, if this tribunal finds that discrimination has occurred in that respect, then this can be evidence of a repudiatory breach of contract. So this takes me to the decision on discrimination. I have to consider why the step took place, why the claimant's manager moved straight to formal management. Was it, as the claimant claims, as a result of her disclosure, that she was beginning the process of transitioning from the female to the male gender? Let me begin by setting out the relevant law. Section 13 of the Equality Act provides that discrimination occurs if, because of a protected characteristic, the claimant is treated less favourably than the claimant was treated or would have been treated. And so we need to look at the because of the protected characteristic. The claimant's relevant protected characteristic is gender reassignment, given that the claimant was at all material times proposing to undergo or was undergoing the process of reassigning her sex. It's for the claimant to prove facts from which this tribunal could conclude, in the absence of an adequate or non-discriminatory explanation from the employer, that the less favourable treatment was linked to the discrimination. If the claimant proves such facts, the burden will shift to the employer to show that a non-discriminatory explanation for the treatment complained of occurred. Guidance as to the shifting burden of proof can be taken from the case of Madarasi and Nomura International PLC, and that case speaks to say that the burden is on the respondent to prove that he has not committed an act of unlawful discrimination. He may prove that an adequate non-discriminatory explanation of the treatment needs to be established. If he does not, the tribunal must uphold the discrimination claim. The protected characteristic need only be a cause of the less favourable treatment. It need not be the only or even the main cause. I remind myself that in respect of this claim, I must be satisfied that the treatment is not simply unreasonable. It must be less favourable treatment compared to somebody who has had the same performance levels as the claimant, but has not announced their decision to transition. And in cases such as these, I'm required to draw inferences from the facts, making findings on the balance of probabilities. In his evidence, Mr. Lewis said he was familiar with the policy. He was a reasonably experienced manager and would normally nip situations in the bud. In that context, I'm unconvinced by his explanation for the decision to commence formal management, given that it is contrary to the respondent's policy and his own admitted usual practice. It's necessary for me to draw an inference from the evidence whether, consciously or unconsciously, the decision to start the formal process was related to the claimant having made her disclosure. The timing of the decision to commence formal proceedings, in the context that Mr. Lewis first had performance concerns at the latest in October 2020, so the performance issue was in existence for some time, and Mr. Lewis gave an on-track rating, albeit admitting some concerns. And it was only after the claimant's disclosure and after not having discussed anything informally and not having given any disclosure consideration to support for her transition, that he decides to address the issue and jumps a stage in the process by so doing. And this leads me to find that the decision was unfavourable treatment related to the claimant's protected characteristic. I also find that this is a repudiatory or fundamental breach of contract by breaching her trust and confidence. The claimant was entitled to trust her employer that her performance would be managed based on an objective assessment of her performance, and that assessment being blind to any of her protected characteristics and having been carried out in line with the stated policy. Even absenting their less favourable treatment, I find that Mr. Lewis's conduct, comprising a decision to misstate to the claimant through the process his real view of her performance, only then to jump a stage in the process for no apparent reason, other than the passing of time, is a breach of the implied term, amounting to constructive dismissal. This concludes the judgment of the tribunal. The case will be listed for a remedies hearing, at which I invite submissions from both parties in terms of the claimant's failure to raise agreements internally. Now, normally what happens is everybody has to leave the room, virtual or otherwise. So you all come out and go, what just happened there? Yeah. But we've got the opportunity to explore what just happened there. So Stephen, talk us through it from the decision that was made.
So what the decision that's been made, and you've clearly set out, is that the tribunal have clearly looked at the legislative requirements and they've considered the facts and placed those facts against that. Now, what often happens, as you've just said, Vicky, is we walk out the room and everybody's, what's happened, or I don't agree with that. we want to appeal, we want to challenge, and that happens from claimants and from individuals. The chance of appeal and the way that you've constructed that would be very, very limited in this case and in the majority of cases, because the opportunity to appeal is only if there has been an error of fact, or it would be so perverse. And as we saw from the polls that we took, although the views swung, the outcome was not perverse. There was a split decision, and therefore it was open in this case for tribunals to go either way, whether you agree with it or not. And that's the risk of litigation, which we often talk about. So yeah, you've applied the facts, you've put it to the law. Everybody was on point about the delay. There's no explanation about that and the loss of trust and confidence that would have caused to be hit out of the blue. And then did the issue of, did the employer shift that burden of proof once it come across them? Well, that's for the tribunal to decide, and you were clear in your judgment on that, and that's it. So sometimes it hits hard, but it's beyond your control. Once you're in that tribunal, it's beyond your control, and that's the important lesson from a judgment. What I've just put on the chat, there's a couple of things, is always take the learnings. Whether or not you've won or lost, take time to sit down with the individuals involved and with the business to say, what could we have done better? What would we do better going forward? Training, somebody said, oh, I wouldn't want to be the HR manager. No, you wouldn't. But that really shows when we all talk about policies and everybody says, oh, I know it's HR again. That's where we're really adding the value. So training can have the best policies in the world, but if you're not demonstrating or not complying with those, not worth the paper they're on. So make sure you've got good policies, make sure they're up to date. Quick refresher most of the time, that's all it takes, and train. And then it's for HR to call that person out. And the final point in the chat was, would this manager be disciplined? I don't think so in this case. And the reason being is he's made a judgment call at best, but worst, he's been foolish in that he didn't do those issues. But we are all people, we all make mistakes. You would have a far better manager who won't forget this experience. This will have been the best training for this manager ever. And therefore your learnings would have been absolutely fine. Now, an exception to that would be if he had been negligent, so he's been trained, or he's deliberately gone out off on a limb, then I think that's the point where you would turn around and say, yeah, we would discipline, but you would discipline him before the judgment, before the tribunal went to full hearing. And that may be a defence to say, look, we hold our hands up, we've taken necessary steps, etc., etc. But that's just an admission, effectively, you've done something wrong. So I don't think disciplinary would actually take place in the majority of cases unless it was blatant disregard for advice or negligence, which is a high bar. You're far better to take the learnings and get that and use that manager as an example, not as an example, but to use that within the business to make sure the management workforce is trained and we don't make those mistakes again.
Yeah, absolutely. I couldn't agree with you more. This is about understanding the unconscious effects of or unintentional consequences of not showing your workings, not managing promptly, not being clear and open. Why is it that this manager is wanting a hybrid marking in between the two? Well, that speaks to me of a lack of confidence in having a difficult conversation. So actually, let's make sure that we give this manager and any others that are in a similar boat good understandings of the importance of dealing with things promptly and showing your working.
Yeah, if you win a tribunal, even as the advocate, and I don't have any real skin in the game, is it, if you lose a tribunal, that's enough. You don't forget that. I say going to a tribunal is the best training you can have because it pulls everything together. But it's the supportive approach that you take afterwards that really adds value. Whether you win or lose, the real benefit of a tribunal is it's your key for improving things going forward.
Yeah, absolutely. And when you say the best training you could ever have, aside from good quality Vista training, obviously, Stephen, yes?
Yeah, obviously, yeah, that went without saying. But yeah, you don't want to be in tribunal. So preventative and proactiveness is absolutely key. But if you do, rather than looking at hanging people out and so forth, that supportive approach is absolutely, yeah. Either side of tribunal, but preferably before you end up in trouble.
Quite so. So there are one or two other questions that have come through on the chat. So in our remaining 5 minutes, let's make sure that we capture those. A good question that's come up that's sort of a satellite point, I guess, around can we ask what the best practice is in relation to the names of employees or identifiers in data subject access requests? So obviously this document was disclosable, this email was disclosable because Jude was identifiable by her name. So there's a suggestion here around, could you use code names or initials? Talk us through it, Stephen.
Yeah, we're lawyers and we're officers of the court, so we're not going to advise you to break the law. But what I would say is that your data protection officers and policies will be clear on what you should do, where you retain records and what you retain. I think the simplest answer to that is if you put anything in writing, whether it be a post-it, text to your friend, work on the basis that would you really want that to come out? If you're nervous about somebody seeing that, then you shouldn't be putting it in writing.
Quite so.
There's a number of conversations go on. We're not stupid enough to say conversations don't take place, but conversations aren't disclosable unless it comes out in witness evidence. As soon as you put something in writing, you can be as clever as you like. Some people do initials. People will ask for disclosure based on initials. Nicknames, and names. So once you're getting into that, there's something wrong. You'd be far better to say, should I be putting this in writing? Is the short answer.
Quite so. Quite so. You know, this manager, if he had some concerns or doubts, he should have had a conversation with his manager about what should be the appropriate rating, and that manager should have coached and guided him, shouldn't he? That's the key point here. Good.
This would have been a simple, look, I don't want to demotivate you. I don't want to demotivate the person. So you could say, look, I'm going to give you on track, but then have a 2-minute conversation. So I'm giving you on track. These are the concerns. I don't want you to slip off that. That would have been enough. And that's the advice I could have given, even if you've stuck to those rules in those particular categories.
Quite so. Good stuff. Lovely. Thank you. Now, Jen, Yvonne, Joe, were there any other points that you saw on the chat that we haven't addressed? Help us out here, because there have been so many good observations made on the chat.
Whilst you're looking at that for the next one, I'll just deal with the last one that's come up, which is how and when awards are reached. You've got to be prepared that they will go straight into that. As soon as they've given their judgment, they are entitled to go straight into what we call remedy, which is the compensation. So you've got to be prepared before you go to tribunal to deal with those on the day. In discrimination cases, often because of the facts are more complicated than this, or there's so much to get through, they will reserve their judgment. And therefore you're prepared to come back once they've given their judgment at stage. But short answer is be ready to deal with remedies as soon as they give their judgment. Don't rock up and think you'll get more time to deal with that at another date. That's not the case.
There's another question about whether any settlement would be reduced because the claimant didn't raise a grievance before resigning.
Oh, that's a really good question. Sorry, Stephen, go on after you.
Yeah, I was just going to say, I think we addressed that slightly before in the yes, we would make that. I don't think it would be 100% reduction, but that would be down. You're in the laps of the gods, i.e. the tribunal panel. If they felt there was sufficient lack of trust and confidence, then they would probably just say, well, with the loss of trust, the door's open for the tribunal to say, we're not going to give a reduction. In my experience, I'd be certainly looking for a 10 to 15% reduction on the basis that that's the whole point of grievance procedures. Had she raised the issue of being performance managed, that would have been able to resolve it before it got to tribunal. And that's why the ACAS codes and penalties are there, is to encourage people to do that. So I think you would get a reduction of 10 to 15% at least. I'd be disappointed if you didn't. The door is open to tribunal. It's purely discretionary.
So remember that because the claimant has won both aspects of her claim, the compensation will be calculated based on loss of earnings and injury to feelings as per the so-called Vento guidelines, which give bands in terms of sort of seriousness. Gut feel, Stephen, from your point of view, as to which Vento band this would be?
I think the tribunal in this case would probably go top end of the lower band. We will be, as a respondent, I'd be pushing for lower band. It's a one-off event which actually triggered the resignation, and it hasn't been a long course of events. It's probably not the most serious. So we certainly be arguing lower band, which in round figures is just under 1,000 up to just under 10,000. Tribunals in cases like this, if they're not sure, they normally go either top end of the lower band or just over into the lower end of the middle band. So you're then looking at around 10 to 12,000, I would say there. So I'd say on this case, you'd be, if you got away with less than 8,000, you'd be happy. If you were somewhere between 8 and 12, you'd probably take it on the chin. It certainly wouldn't be worth appealing, which is why they go around that band.
That's right. Absolutely right. Good. I'm conscious.
Another question about whether the line manager could be personally liable for some of that settlement because of the discrimination in that.
Yeah.
I think we picked that slightly further up in the chat, in that if an organisation has been able to demonstrate that they provided all of the training, all of the structure to prevent discrimination in the business, then it's more likely, isn't it, that the claimant will go for the manager rather than for the organisation. But not always, isn't it?
That's it. And you would be able to identify that if the claim had been made against both the organisation and Mr. Lewis personally, and that hasn't been the case in this particular case, which would be typical with this sort of discrimination claim as opposed to, say, a harassment type situation. Good.
There is the opportunity. Sorry, Vicky, I know you're going to wrap up. There is the opportunity if the individual and the company are sued, the company does have that extra defence if they can show they put reasonable training in place and took reasonable steps. It's called a statute defence, where they can hang the manager out to dry effectively. But that is rare. I think I've only had that in one case where we've advised somebody to go there and get their own independent advice, but it's very rare. You normally stand together on these cases and go from there.
Wonderful. Thank you, Stephen. Joe, I'm conscious we're going to be at risk of outstaying our welcome with you. So let me hand over to you to close it up. Thank you so much.
No problem. Thanks very much, everybody. And that was just amazing. I'm sure that all the listeners took a lot away from that. So thanks very much to Vista. I will send out some correspondence this evening to the people that have signed up for the event. And I will put a post on LinkedIn detailing how you can access a copy of the mock tribunal handbook from Vista and also a copy of the recording. So if you can put a comment on LinkedIn against the post, then this would be appreciated. We've got another event next week on Tuesday on the 17th, which is called Talking Menopause. Details about that will be included in the email. We do also have a guild networking group for HR professionals. It's a little bit similar to WhatsApp group where members can ask questions, network and share ideas. So a link will be included on the email about that. And also, if anybody is recruiting, obviously I work for HR Recruit. We also have Accountancy Recruit and FD Recruit within the group as well. But otherwise, I'd like to say a massive thanks to Vista for your time and effort into putting the mock tribunal together, and also to the listeners for tuning in. Thanks very much.